Good morning, everybody. Thank you for joining us this morning on our third session now in terms of identifying risk from the outset in inquest. I've also got Zara, as Heather helpfully introduced her there, to assist with this webinar too. First of all, I'll take you through what this inquest is, what this webinar is likely to cover. It will cover what an inquest is, what is considered as risk, ways in which risk can be identified early throughout the inquest process, practical tips on front-loading your case, investigation and analysis, the benefits of identifying risk early, and ways in which risk can be managed prior to inquest attendance. I'm just going to hand you over briefly to Zara now, who's going to take you through when an inquest might arise and just tell you a little bit about the legislation around that as a helpful reminder and to set the scene before we go into the substantive risk elements of this webinar.
Thank you. So just to set up a bit of background, an inquest is an investigation into a death which appears to be unknown, violent, or a result of unnatural causes. So to follow up, a medical practitioner will have a duty to notify the coroner for the relevant area if one or more circumstances apply. So in a hospital context, this is likely to concern a death whereby the cause is unknown, unnatural, and they died whilst being in custody. So just to follow up, the coroner will also have a duty to investigate the death. And as you can see, it is a similar set of scenarios. I think what's important to highlight here is an inquest is a non-adversarial process. It's not there to lay blame to any individual or organisation. It's just simply for the coroner to find out how the deceased came about their death. There's also instances in a hospital where there could be a naturally occurring event, like pneumonia, for instance, and it can overlap with an unnatural event. So the patient could fall and have a fractured neck or femur and then passed away. The coroner would then be obliged to investigate the death. Back over to Sam now to discuss the risks in an inquest.
Thank you, Zara. So when we talk about risk in inquests, I think first of all, it's really important to set out that not every inquest that you are asked as a trust or an organisation to assist with will have issues. By and large, the majority of inquests that you see in-house will be absolutely fine. There'll be a request for a witness statement. You'll get the witness statement. You'll send it off to the coroner and you won't hear any more about it. There will be some instances where you have the few cases that come across your desk where there are potential issues, there are potential risks for the trust. Things might not have gone as they should have in relation to the care and treatment. When we talk about trusts, we're also talking about your social care providers as well. Appreciate there may be people that have joined on the call today that are part of other organisations and just apply the advice as we go along in terms of what the circumstances are for your particular organisation, whether that's a local authority, for instance, or if you're an insurance broker working on behalf of a different organisation. But for the purposes of this webinar, we're talking about the healthcare sector, we're talking about trusts, and we're talking about the social care providers. Now, when we talk about risk, as I said, we're looking at whether there's a risk of the issuing of a prevention of future death report under Regulation 28 of the Coroner's Inquest Regulations 2013, which no doubt many of you on the call will be aware of in terms of what that means and what the detail is. But of course, if you need me to expand on that after the webinar, we can discuss that further if you have any questions around that. There could be criticism handed down within a narrative conclusion. There could be risks of a neglect rider, which is usually in cases where there's a failure to provide basic medical treatment. There could be risks of CQC and or GMC involvement. To add to that, we could be looking at an NMC involvement as well, where nurses are concerned. There may be criminal referrals made by the coroner. or consideration of criminal referrals. There's also the risk of future clinical negligence claims as well, and also negative publicity, because not forgetting that, of course, an inquest is a public hearing, and therefore press can be in attendance. Just moving on then, there are ways in which risk can be identified early. Now, we're going from the very beginning where you're first made aware of an inquest, or your trust is first asked for assistance with an inquest, whether that's with a request for witness statements, or it could be an inquiry from the coroner to start with in the first instance. Now, the ways in which we might identify risk early is as a result of maybe the cause of death maybe give us an indication that there may be issues. The coronial request itself might allude to potential issues or give you an indication that the coroner is concerned about certain aspects of the care and treatment. We might have incident reports linked to the deceased's medical record that raises concern. The family may have raised concerns themselves. PALs and complaints might be able to assist with that. There may be an internal review or investigation that's ongoing that will flag up potential concerns, or the court bundle itself. Now, we do know we don't always get access to the court bundle unless we are considered an interested person. We can ask for the court bundle. The coroner will sometimes give it and also provide an interested person status at the same time. But of course, that is very late in the coronial process. So there's lots of other avenues that we could explore in the initial circumstances to see if our trust or social care provider has potentially got any concerns. We're going to go through each one of those in turn now, just giving you an idea of the kind of considerations that I would have if I was looking at the coronial request itself. The coronial request is a letter, as we all know, and it comes in, it's from the coroner, and it says, I've opened this inquest into the death of X. Usually we see a bog standard request for witness statements from clinicians who had involvement in the care and treatment of the deceased. And it might be that you're not given any further information, and that is all you have. Sometimes the coroner might have particular questions at that stage from the outset that he wants to glean from a particular witness at your trust. He or she might have alluded to a specific period of time. That's helpful because it will give you an idea as to whether you're looking at either the last attendance or whether it's the attendance before, or it's a collection of attendances that someone might have had. So that gives you an idea. The coroner might ask for a witness statement from a specific specialism, such as tissue viability. Which again will give you an indication that potentially the deceased had some involvement by the tissue viability teams, and in which case straight away you can contact the head of service for tissue viability and say, I've had an inquest request. We've had an inquest listed for X. Can you tell us a little bit more about the care and treatment or the involvement? Are we concerned about the care and treatment from a tissue viability perspective? And you can open up a conversation just in relation to that, just to see if someone else can tell you a little bit more about the care and treatment. Has the coroner alluded to more than one hospital attendance? Sometimes this can be an indication that someone may have attended, they've been discharged, and then they've attended again within, say, a week or a couple of days. If that is the case, for me, I'd be thinking, well, why was they discharged? Do we need to speak to the discharging consultant about that? Was it appropriate for them to be discharged? So there's just all of these questions that kind of spring to mind straight away, where you could just satisfy yourself that there isn't anything that we need to be concerned about from the very outset. And this is what it's about. You're not going out there asking 10,000 questions about the care and treatment and looking for issues. That's not what this is about. This is just about you as the lawyer for the trust or director for the investigator, whoever's dealing with the inquest request in-house, just to satisfy yourself that there's nothing that needs to be looked into further. Has the coroner asked if an internal investigation has commenced? Sometimes that can be a little bit of a, ooh, why is the coroner interested in whether there's an internal investigation? Does he suspect that there should be? Is he concerned? Why is he concerned? Is there any concerns that is alluded to? Just another thing to bear in mind is how old was the deceased? Now, in the case of children, babies, young adults, it might be that the care and treatment, there's no issue whatsoever, but I'd always have those particular inquests as a red rating, if you like, just to keep your eye on them, just to make sure that everything is going as you expect in terms of the internal aspects, because they just carry an additional sensitivity about them, and witnesses will need to be managed in probably a more sensitive way depending on the circumstances. Has a particular clinician been named on the original request from the coroner? If it has, that sometimes can make your job a little bit easier because you know who it is that you need to go directly to for a witness statement. You can open up a conversation straight away about the care and treatment and whether, from that clinician's point of view, they were happy with everything that it took place in terms of the care and treatment. Has the coroner granted interested person status to the trust? Sometimes the coroner will grant interested person statement from the outset. It could indicate that there's potential risk in the inquest, or there's potential concern for the coroner, but at the same time, it might be that the coroner is giving interested person statement from the outset because it's easier to do that than get further down the line or get to inquest itself and then have to do it. Because of course, if you do have interested person status, it means the coroner considers that the trust or the organisation has a sufficient interest in the inquest, and therefore it gives certain rights in terms of access to the court bundle and right for legal representation if you want it. It's not the coroner saying, I think you should have legal representation. It's a more an option for the trust or organisation to consider whether that's necessary. And by doing your due diligence and looking at risk from the outset and doing the various investigations that you can with the tools that and the documents and the people around you from the outset, that will give you then an idea as to whether it's something that the trust might need a little help with or not. Moving on then, sometimes the initial coronal request will say what the medical cause of death is. It won't always be the case. It might be there's a post-mortem taking place and we don't actually quite know at that point what the cause of death is. So it's quite usual from the start of an inquest, certainly, for there not to be a decision on the cause of death at that point, and we're waiting for the pathologist to complete post-mortem and take a view. But where you do and where you are given that information, sometimes when we have the cause of death formulation, it might be that that will then give us food for thought in terms of any additional questions or any additional investigations internally that we might want to do, again, to satisfy ourselves that everything that should have taken place took its place and we're not worried at all. So I've just provided a few examples there just to give you an idea of what it is that I'm getting at there. So the first one is 1A, sepsis. So this person has the primary cause of death is sepsis infection. So if we work from the bottom, 1C, they've had a fall. We know that they've had a fall. 1B, we know that they've suffered from an infected sacral pressure sore. And then, of course, 1A, as we just mentioned, is sepsis. So my thought process there in relation to that cause of death would be, first of all, okay, so this person suffered a fall, which has caused a pressure sore. I'd be straight away thinking, where did that fall occur? Has someone come in following a fall and they've been treated for the fall itself, or have they fallen whilst in our care? If they've fallen whilst in our care, the trust care, then you'd be thinking, were the relevant falls risk assessments, had they taken place? Were they appropriate? Were they followed? Is there any risk there for the trust from that perspective? Speak to the falls lead nurse. Some trusts do have falls lead nurses who might have this particular person on their radar if they have fallen and suffered an injury. Speak to them, see if we've got any concerns, check that the relevant risk assessments are taking place, did the relevant falls prevention mechanisms in place, did they have a call bell, did they have side rails, did they need them, was there capacity an issue? All of these questions. Now, the people that can help you with that would be the nursing staff on the ward that that person was on. So it's a case of getting in touch with them, briefly. If you can, have a telephone call if they're free. Just say, I want just 10 minutes of your time just to discuss this person and see what you can find out. Again, infected sacral pressure sore. This person's had suffered pressure sores, had their hospital-acquired pressure sores. It follows that if someone suffered a fall, they might have had an orthopedic injury and therefore been bedbound. And we know that being bedbound, you're at higher risk of pressure sores, and these ones have become infected. So we want to know that these sacral pressure sores have been treated and cared for in the right way, so as not to cause them to get worse. It might be that tissue viability have been involved in that respect. Sometimes they're involved, they're not always involved, but it's a question that you could ask. And then just in relation to the sepsis itself, we can assume from this cause of death that the infected sacral pressure sore has caused sepsis. Was the sepsis identified? Was it treated? So really you're working backwards from bottom up, and you're asking all of the relevant questions of the relevant clinicians, and right from the outset, just to make sure that you're happy that everything that should have happened in the way that it should have happened whilst this person was in the trust's care. So moving on to the next example, we've got 1A, a subdural hematoma, and 1B, a fall. Again, the same thought process in relation to the fall. Where did that fall occur? Was it in the hospital setting? Was it outside? If it was in the hospital setting, you go through the usual questions in terms of falls risk, and were we happy with that side of things? If it was outside of the hospital setting, and they say for instance, someone's come in, they've suffered a fall, they might have fallen, and they may have banged their head. It might not have been completely apparent when they presented to A&E that they had banged their head. They didn't report that they'd suffered a blow to their head, and therefore it might be that a CT scan hasn't been considered because it might be there was no reason to consider a CT scan. So we're looking at whether the CT scan took place. We know that a CT scan would have eventually took place because a subdural hematoma has been identified. Did that CT scan take place when it should have? Was it reasonable to wait? Did they wait? So all those kind of considerations as well, and the questions that you can ask from the very outset if you're provided with a cause of death formulation. Okay. Another place that we could potentially look whether there are any concerns is whether the family themselves have raised any concerns. Has the coroner alluded to the fact that the family has got concerns? Sometimes they do, sometimes the family would like to know X, Y, and Z. That can then give you an indication as to whether there's any risk from that perspective. Sometimes families' concerns can go outside of the scope of the inquest, and that's not uncommon. So it's about you applying, thought process in relation to that as to whether those concerns go to the heart and the scope of the inquest itself and the death, or whether they're concerns outside of that. Relevant concerns and concerns that obviously need to be taken very seriously and responded to in the right way. But for the purposes of the inquest, do they affect your thought process and your risk profile in terms of the inquest itself? Is there an ongoing complaint? What does this tell us? Speak to the lead investigator, the clinicians involved. Sometimes there may have already been a complaint raised about care and treatment, and this is where our friends in the PALS and complaints team can assist and give whatever information that they've got about this patient's journey and about what the concerns of the family were. And then you'll start to find a picture then as to whether that, again, for the purposes of the inquest and the death itself, it might be the concerns were unrelated to the death, and therefore you can almost put that to one side for your purposes, for the purposes of the inquest, in terms of the risk at the inquest. But of course, it might be that the coroner or family want to raise that at the inquest as well. If it's out of scope, sometimes the coroner will speak to the family and say, well, actually, that's something that can be responded to through other avenues. But some coroners will let them ask the question if a clinician can answer it. So it's just being mindful of that. Make any relevant clinician aware of the family concerns and ask for comments from the outset. Get the clinicians to help you with that. Say, well, this is the family's perspective. This is how they saw things. Do you agree that there was a delay with the surgery? Do you agree that they were left, they weren't assessed for falls? Did you have any concerns with the capacity? Whatever those concerns are from family, speak to a clinician about it and ask what their view is from review of the medical notes or their experience themselves if they actually treated that person. If there are no family concerns that you're aware of, it's perfectly usual and normal to ask the coroner from the outset whether the family have raised any concerns, because you'd like to deal with them, you'd like to address them. And it is quite a common question for the coroner to ask family members about whether they've got any concerns about the care and treatment. They will ask the direct question of family members in respect of that. More often than not, the answer will be no. Sometimes the answer is yes, and it just gives you a little bit of an idea as to what further questions you might need to ask prior to the inquest itself. Okay. Some questions to ask yourself when considering a new coronial request. Has an incident been raised relating to the care and treatment of the deceased? So we've got, whether you're working from Ulysses or Datix systems, you may have a number of bits of information at your disposal. We know that where there are potential issues or lapses in care, an incident should be raised and can be raised, and that might give you an indication as to whether there's any particular issue with the care and treatment. Again, may be completely unrelated to the death itself, but again, a good resource, a good place to look. There may have already have been an internal investigation started, whatever form that's taken, because we do know that that's now changed since the introduction of PSERF, so it might be depending on the circumstances, and we don't always have or see an investigation. It might be an investigation was considered not necessary following the incident itself, but you might have some additional information there just to check out and to give you an indication as to whether you need to be concerned about this particular case itself and the inquest. Did the incident, like we said, lead to an internal investigation, a mortality review? Does this what does this tell us? Can it give us any further information? Does it give us any further information in relation to the clinicians that might have been involved? It might give you the names of clinicians who can be really helpful, and you can go direct to them and say, I've got this inquest, there's been this incident, what can you tell us about the care and treatment? And this is all from the outset. This is before we've even started to approach anyone formally for a witness statement. So these are all things that we can do in-house to just get a little bit more information. And when we do that, you know, it gives us the benefit of putting any particularly any inquest that we might be concerned about on the radar of your senior leader team as well, and making sure that they're briefed in advance, because they can help. They can help with the investigation. They can help with contacting other people and getting responses. So do use everybody around you. And again, hand in hand with that, check in with the wider governance teams to see if they can provide you with any information of whether this patient is known to them. So we've got, you know, PALs and complaints, we've got the patient safety teams, you know, all of which can really help with any additional information that we might need. Okay, and following on from that, and one of the things that I like to stress is don't work in silo to the wider governance teams. They will have an abundance of, if not information about that particular patient themselves, it might be that they're not aware of them, but usually governance teams will be made up of various, you know, personnel that have got clinical backgrounds. And if you're not clinical, which I'm not, they can really help with you understanding certain aspects, or maybe point you in the right direction as to who it is. If they don't know a particular bit of information, or who you should, if you don't know who you should contact, they might know who best person is to contact in the trust. Because again, we know that trusts are made up of lots and lots of people in various different roles, that sometimes we might not always contact the right person for the right information, and that's usual normal, because of course there's so many people. So it's about trying to find the right person that can help you the most as well. So involve the wider governance teams in your inquiries. If they are aware of a patient and they have something ongoing, whether that's a family, whether that's a complaint response, or whether it's an internal investigation, ask to be updated, diarise to be updated, diarise it in your calendar to check back in with them. Use their medical knowledge and expertise, as we have always already said. Diarise to chase any outstanding information regularly. And don't overly use email if you can make a call. Another favourite one of mine, and I know it's all well and good, isn't it? When we're all really, really busy, sending off quick email is sometimes far quicker, but we don't know if that person's at the desk. If it's someone that works clinically as well, they might not be at their desk for a couple of days or even a week. They might be on, you know, their break. So if you can make a call, pick up a phone. And not least, it also helps with relationships as well, and building those relationships internally. So yeah, a favourite one of mine. Okay. When we get to it, we're going to be asking clinicians to write us a witness statement for the benefit of the inquest. Once we've identified who that person is and who's the most appropriate person, they will put together a witness statement for us. Now, usually the coroner will request for the witness statement to be provided within 28 days of the request. Try where possible to stick to that deadline. It's challenging, it's really challenging. It's challenging for legal services, because of course you need to firstly identify who the right witness is. So that can take some time from the outset in the first instance. But in addition to that, it's challenging for that witness as well, because of course they're no doubt working clinically. And to be able to get the time to sit down and apply the mind to a witness statement that's been requested, analyse the medical records, try and recount back in terms of the care and treatment, that can take some time as well. Coroners will appreciate that it can't always be achieved, the 28-day time frame, but what they don't appreciate is when that 28 days has passed and they've just not heard anything from you. So my top tip advice in that respect would be, if it's looking like you need more time, let the coroner know, explain that there's, at the minute we've got a lot of winter pressures, so of course that takes us even further away from being able to sit down and write a witness statement. You know, it might be someone's on annual leave, they might have had a period of sick leave, whatever it might be, just let the coroner know, keep them updated. And if you keep them updated and ask respectfully for an extension under the circumstances, as long as the inquest isn't imminent, I'm sure you will get a positive response, but just keep them updated. Make the coroner's clerks, you know, build a really good relationship with your coroner's clerks as well. You know, appreciate their role, show that you appreciate what they're doing. You know, make it known that you're grateful for their help, and, you know, build a good relationship with your coroner's clerks, because they are your middleman between, you know, yourself and the coroner. So if you've got a good relationship with them, you're likely to get what you need from them, whether it's being requested for an extension, a copy of the post-mortem report, and whatever it might be. So do build a good relationship with various coroner's clerks that you come across. So in terms of the witness statement itself, we're looking at whether it covers the information requested. Don't be afraid, once you're reviewing the witness evidence, don't be afraid to clarify anything that isn't clear. I do that time and time again, because sometimes when you're reading a document that's heavily, you know, and clinically involved as well, from the perspective of someone that isn't clinical, things won't always make sense straight away. There may be questions that come out of the evidence itself. So go back and clarify, and, you know, just say, I'm just wondering about this. Can you just help me? And I'm sure the relevant clinician will be able to assist. Use the clinician and ask if the clinician has any concerns about the care and treatment provided. By and large, the answer will be no. Generally, you will get no, I don't have any concerns. Don't wait for the pre-inquest meeting. So we do have, and I know things, you know, work the same way internally as well in-house, that you will generally have a pre-inquest meeting with your clinicians that are looking to attend inquest, and that will happen in potentially all inquests before they, just to brief them and let them know you know, what is expected of them at inquest. If you have any questions in and around the witness evidence, ask that earlier than the pre-inquest meeting. The pre-inquest meeting will no doubt take place 2 weeks, you know, 3 weeks before the inquest itself. Ask any of those questions beforehand if you have any, because if any concerns are raised, it gives you more time to deal with them. It gives you more time to explore them. So do try and do that where you can. Within the witness statement itself, does any of the content itself raise any particularly concerns for you? Does it allude to faulty equipment? Does it allude to any missed doses of medication? Delays to treatment itself or CT scans? Does it allude to any bleeding or anticoagulation therapy? Of course, if we've got bleeding, then you would expect in certain circumstances, if not all, that anticoagulation therapy would be considered in more detail in terms of having that stopped, because of course we know that that can make bleeding worse. So just being alive to those types of questions as well. Is there reference to an inpatient fall, and therefore do we need to ask a little bit about falls risk assessment? So again, those considerations as you go through the witness evidence. And if you read the witness statement, and more 9 times out of 10, you will read a witness statement and you'll be satisfied with what it tells you. And that's not uncommon, and that's absolutely fine. And there's no reason under those circumstances why you can't then wait for a pre-inquest meeting just to clarify the information and just to go over the evidence that you've been provided with. Okay. So when we've gone through all of those steps and we've looked at all of those and we've gone down all of those different avenues, and it might be that we do have concerns. It might be that we do have an internal investigation that's flagged various concerns in relation to the care and treatment. It might be that through your analysis and investigation, through speaking to various different personnel within the trust, that they do have potential concerns, and there might be risks. There might not be risks in terms of any particular lapses in care causing or contributing to this person's ultimate outcome, but there may be considerations and concerns around prevention of future deaths in the future. Now, we know, don't we, that the coroner's prevention of future deaths hat that he has to wear at inquest doesn't just consider this particular deceased itself. It considers whether there's lapses in care that, if left to continue or where action hasn't been taken, future deaths concerning other patients might occur. So where we've identified particular issues in relation to those aspects, it gives us, as a trust or care provider, more time to prepare for the inquest. If needed, and it's not always needed, we have some really experienced in-house legal teams across the country. You don't always make the decision to instruct legal representation, and that's absolutely your prerogative. You don't need to, but it gives you the opportunity, if you want some further help, to consider instructing some further help if you need it, and if you feel that that's required for your trust in those circumstances. It gives the trust an opportunity to commence an investigation in some circumstances if one is required. Sometimes it might be that an investigation hasn't been commenced, but through your considerations and through speaking with people and through your analysis of a particular case and various bits of information that's come to light since, it might be that the trust considers, well, actually, we need to look into this internally more in depth, and it might be that an investigation is started at that point, which in turn will go on then to inform the inquest process further down the line. If pre-inquest admissions are required, these can be dealt with early. That may save costs in any future claims, and it may limit the extent of witness attendance that's needed at the inquest. Now, that's really important, and a very important point there, because if through our analysis we've seen a trust investigation and say, well, actually, unfortunately, the lapses in care have contributed to some extent to this person's ultimate outcome on the balance of probabilities, then where possible, there's a number of things then that need to happen to protect the trust further down the line, not just in relation to the inquest itself, but in relation to any potential future claim in clinical negligence. And of course, we need to work closely in that respect with our NHSR colleagues as well, making them aware and updating them of the trust position, so then they can adequately send the correct response and consider the case seriously from their perspective, and make any decisions that need to be made pre-inquest. And therefore, should a clinical negligence claim arrive on the back of an inquest, any costs, solicitors' costs on behalf of the claimant in that case then are reduced significantly, because of course there's already been some concessions in relation to any breach of duty and causation in that respect. So that's really important. So when we say don't work in silo to governance teams, equally and as equally important, don't work in silo to any NHS or handler that might be aware of this particular case for whatever reason. It gives you more time to consider and prepare assurances to avoid prevention of future deaths and any adverse outcome. It gives you more time. So as part of the inquest itself, the coroner will want to be satisfied that any lapses in care that have been flagged, there's been action taken to ensure that those lapses don't occur in the future. And the way that we do that is to, provide evidence to the coroner that the trust has ultimately taken action in that respect. So it gives you more time to consider those and how you might present that to the coroner at inquest, because it's certainly something that he or she will be interested in. Identifying any potential issues of concern risk will also ensure that any witnesses that are attending inquest are fully supported and briefed in advance of the inquest. And then it limits the risk of any new issues coming to light that haven't been considered. Now, I say that lightly in the sense that we've all attended, no doubt we've all attended or been involved in inquests where, no matter how much we have asked the relevant questions and we are content that we've done everything that we need to do prior to inquest, we get into inquest and we hear some evidence from a witness that we hadn't anticipated or we couldn't have been aware of, and particular issues do arise. So we can't always fully mitigate the risk of, issues coming up further down the line and that inquest, and they need to be managed as appropriately as we can. But of course, by going through these steps before you get to inquest, you're putting yourself in the very best position to ensure that you've done everything that you possibly can to ensure that you've prepared in the best way that you can and that you've got everything in place to, assist the coroner as much as you possibly can, but of course protect the trust that you're, or the social care provider that you're working for, and to provide that assurance to the coroner as well. Okay. And that goes hand in hand with what we say here, where lapses in care have been identified. It'll be sensible to submit evidence to the coroner in support of your organisation's commitment to learning in advance of the inquest. Now, sometimes this process is an ongoing process. I see action plans, well thought out, action plans with various deadlines as to when actions may be completed, or if they have been completed. What you need to be doing prior to inquest is ensuring that the trust is moving forward to a place where you've got an action plan and the actions have been taken. The coroner, when considering any prevention of future deaths report, can take into account a commitment to carry out further actions, and representation should be made at inquest in that respect, where, say, for instance, the trust has committed to do something, but something's actually not taken place yet, and it's for taking place in a date in the future. The coroner should be reminded of that and reminded that he or she can take into account that commitment where possible. And the best case scenario would be to ensure that those actions have been taken. You can sit in front of the coroner and say, we identified these lapses in care. This is how we're going to make sure that it doesn't happen again through these actions that have been taken. These are now in place and they are now fully embedded within the trust processes. But do make sure that if the coroner wants to hear from a witness on the action plan or the assurances that you've provided, make sure that witness is absolutely the most appropriate witness to provide that evidence. We don't want someone sitting in front of the coroner almost reading off what the trust have said that they will do and that they'll do it if we can help it. We want someone that's actually involved in rolling out those actions. It won't always be that same person, because we know there could be a number of different specialisms involved in various different actions that are being taken, and that's okay. But as long as whoever is presenting that action plan has some degree of knowledge about how that's going, how it's working, if we can offer up an audit, that's gold standard, because we're able to say to the coroner, yes, we're doing all of these things. We've put all of these things in place. And we know it's working because we've also conducted this audit of the last, over the last 6 months or the last 3 months, where we've checked that these things are being adhered to and these processes are in place and staff are aware of what's expected. That's gold standard. If you can get that really is, gold standard assurance for the coroner. In some cases, it's not always possible because that's a time-consuming exercise. So I'm not for 1 minute suggesting that you should attend inquest with that, because sometimes it's not possible, but where you can, it really does help. Assurances, setting out what you said would do, has been done. So that can be in the action plan itself, or it can be a separate document. Whatever process your trust follows to get that point across is absolutely fine. And sometimes it might be that rather than an action plan itself, it could be that a witness statement has been prepared by someone in a particular area, just who's identified there's been a number of, one or a number of lapses in care, that's just addressing that and setting out what the trust are doing moving forward to make sure that does not happen. And like we said earlier, just do identify the most appropriate clinician to provide this evidence at inquest, just to make sure that you've got the right person for the job, basically. So that brings us to the end of the webinar. Just one thing to mention, just in relation to all of that. If there's ever something that you're struggling with, or a question that you're not quite sure of, you've got a particular case that you need a second opinion on, my details will be at the end of the slides once we've dealt with questions, and I'm quite happy for anyone to contact me just for a chat about a particular issue, or just to get a view. I'm quite open to that, so please do use my details if you need them, just for a second view. I know I'm isolating, it can be sometimes working in-house, and sometimes just having that person to bounce something off is invaluable. So please do use me for that if you can, or anyone else, of course, in my team. Okay, that brings us now to questions.
Can I please ask, some of our coroners are asking for a statement to confirm cause of death in order to allow release of the body. This has caused confusion with clinicians, and I wonder your view. The COD referral via the medical examiners and a full statement of care, I thought, were two separate processes.
Thank you. That's an interesting question, and something that we are seeing more often now. The coroner can ask anything they want in terms of clinicians, in terms of any assistance that he or she needs. Certainly in relation to the cause of death, it's not unusual for a coroner to ask a clinician to confirm what their view is in terms of the cause of death itself. Sometimes that can be as part of the care and treatment that's provided, and the cause of death will be dealt with at the end of that statement. Sometimes it might be it's requested in a separate form. It might be a different clinician or medical examiner that is more appropriate to the lead consultant than, say, for instance, who has provided the overview statement of the care and treatment. What I would say in relation to that is, if a cause of death can be provided, the clinician should provide a view. It might be that clinician has one view, and it might be another medical examiner might have a different view. It might be clearer than that. Sometimes it not always is. Sometimes it might be that a cause of death isn't established, or they can't form a view. The most important thing in relation to that scenario is just setting out to the coroner what the position is and what the trust position is. The coroner, when he asks that, isn't saying you must tell me what it is. It's asking for assistance. So if you can tell me or provide a view on the cause of death, I'd be helpful. It'd be, we'd be grateful for that assistance, and see if that particular clinician can provide that help for the coroner.
Our next question. I'm finding that since the introduction of PSERF, and where I have identified issues with care not linked to that death, but that could result in a PFD, that I'm having to fight the patient safety team to review the care because it does not fit into one of the trust's identified safety standards. There is no investigation plans, etc., so we have no evidence to submit.
Yes, another interesting one. And sometimes what I usually find is that it can be as simple as making sure all the teams around you that are working with and with legal and that are interconnected understand to a certain extent, or to a full extent really, of what your pressures are and what your ultimate goal is, and understands what the coroner's expectations will be. We know now, don't we, with the introduction of PSERF, that there won't always be an investigation, and that's the trust's prerogative. That's for the trust to decide whether an investigation needs to take place or not, in the realms of the framework that particular trust has set up in where an investigation is mandated or not. They're two separate processes, and what we always say is, and what we always get across, is that actually whilst the coroner, a trust investigation may assist the coroner and it can be helpful to inquests, it's not completed for the benefit of the inquest itself. It's completed for the trust to identify whether something else needs to be done. Yes, I understand and I appreciate that if there was an investigation, then that would then draw out particular actions that then would be put in place. What I think patient safety teams might be well to understand a little bit more of is actually, well, if there are potential prevention of future death concerns identified, the trust, I guess as a legal representative, what you can't be saying is you must do an investigation, but there has to be someone in the trust that is able to say, oh, okay, well, that's an issue. Is that an issue? I'd put it back on the clinician. Is that an issue? If they say, yes, it is an issue, then it follows, doesn't it, that then there is certain action that needs to be taken, or there's a process that needs to be changed. So, I'd rely on the clinical colleagues to reassure you. If you're being told as the legal representative, well, I understand your concerns, but we're not concerned, and this is why we're not concerned, and this is why our processes are fit for purpose, and there won't be any lapses in care in this respect. If you're told that by the clinician or the clinical team, there's no reason why you can't take that for read, because from my perspective, my view is, well, I'm not clinical and I should be able to trust in the clinical staff to tell me whether there's an issue. If they tell you there's an issue and you find that there's an issue and it comes out of a particular inquest itself, then of course those clinicians, the heads of service, need to look at that seriously, because of course, yes, you're quite right. If there are PFD concerns flagged in your preparation for an inquest, then you need to be reassured by the clinical staff that what you may have thought were concerns aren't concerns. And if they do think they're concerns, then there needs to be some steps taken to make sure that assurance is provided to the coroner in relation to that. That was a very roundabout way of trying to answer the question. So I do hope that I have answered that satisfactorily. But sometimes, yeah, what I would say is that just have a conversation with the patient safety teams and make sure that they fully know and fully understand this additional duty that the coroner has in relation to prevention of future deaths.
Thank you, Sam. Right, our next question starts with a thank you. The webinar's been very helpful and we always appreciate that feedback.
Thank you. Yes, absolutely.
If there has been a post-mortem, should we consider this to be a more high-level case?
No, not necessarily. I wouldn't necessarily place any degree of concern in relation to whether there's been a post-mortem or not. Sometimes a post-mortem is just necessary because, of course, our clinical colleagues are unable to ascertain what the cause of death was, and therefore just needs some more an in-depth investigation internally, whether that's radiologically or not, just to try and find out what the ultimate cause of death was. But I wouldn't necessarily rate that as any higher risk just from the purposes of the fact that a post-mortem has taken place.
Right, thank you. Right, our next question is more of a statement, actually. Somebody's commenting that there should still always be some kind of instant response if it reaches DOC.
Yes. Yeah. If it reaches DOC, I'm assuming that's duty of candor, and I would agree with that. If, say, for instance, there has been some issue flagged with the care and treatment, then if things are happening as they should, generally, as I understand it, a lot of trusts will encourage staff to raise an incident as standard and basic, even if it doesn't follow that a full investigation, whatever form that takes, follows from that particular incident itself. So that's my understanding too. Thank you for that.
Right, thank you. Some coroners are clearly irritated by PSERF and are listing inquests, still expecting investigations to be ready for a listing date and asking us to expedite them if they will not be ready for the inquest date. And this is not possible to achieve. Do you have any advice on this point?
Yes, and quite a common scenario, actually, if that provides any degree of reassurance, actually. Coroners do with an investigation, if there's an ongoing investigation, it's natural for the coroner to want to see that, because of course it gives them the answer. It assists no end, doesn't it? Because it gives them the answers as to whether there's any concerns or what the focus of those concerns might be for the benefit of the inquest. But what we have said, and what I always say, is that the trust investigation isn't completed for the benefit and for the sole purpose of the inquest. If it's about and it's there and it's been completed, it can assist, and it certainly should be disclosed to the coroner if it's ready. I wouldn't be rushing an investigation because the coroner has asked for it. What I would be doing is I would be explaining to the coroner why it's not available. Sometimes coroners do get frustrated because by the time an inquest is listed, we know, don't we, that they should be listed within 6 months of the death now under the Coroners and Justice Act. Now, if, say, for instance, a trust is saying to the coroner, if it's been at least 6 months, sometimes it's longer, more often than not, it is longer before the inquest is listed. And if we as a trust are saying to the coroner, sorry, coroner, but this investigation isn't completed, it's not ready. The reason why some coroners do get frustrated and concerned is that from the timeline, so they will feel that that investigation either hasn't been started quick enough or it's taking longer than it should for whatever reason. The trust just needs to be able to justify why it is taking longer. Sometimes we do have investigations that take longer, depending on how involved the care and treatment is, depending on the terms of reference. It might be that you have a situation where You have a number of different specialisms involved, which is not uncommon from a patient's journey from start to finish in care and treatment. So where you've got a number of specialisms involved and the input is higher, and therefore naturally that will take more time. It might be that there has been a number of trusts involved and one trust is taking the lead on the investigation, but of course you need to check in with the other trust to make sure that they're happy with the input that's been provided. Again, that can take time and quite common where we've seen investigations take longer than expected. The important and key thing is to make sure that the coroner is updated along the way as to if we've already provided the coroner with a completion date and we're not going to meet it for whatever reason, provide the coroner with some degree of explanation as to why it's not ready. The coroner will need to take a view then at that point whether they're going to continue with the inquest and carry on without the copy of the investigation, or whether they're going to adjourn and relist. Now, it depends on the coroner. What the coroner can do in those circumstances is continue without the investigation, but then you're at risk of the coroner saying, well, I want all of the witnesses that have been involved in the investigation to attend court to provide evidence. That's not a situation that you want to be in, because that could be a lot of members of staff. You would naturally go back and say why that wasn't reasonable or possible. Certainly if it's, involving a number of members of staff from the same specialism that will be taken off the ground to attend inquest, that's not going to help anybody, and it's certainly not going to help the trust. Key in relation to that situation is to update the coroner as to where the trust is and provide a realistic time frame from the outset as to when the investigation can be provided. Again, just following on from that, the risks that come about as a result of that situation, as a result of, say, a delayed investigation, is that the coroner may then become concerned that the investigation process isn't working as it should, in the sense that until that investigation has been completed, it's not clear to the trust what actions and what steps need to be taken from a safety perspective. The coroner may assume that, and therefore, if we're 8 months post death, there are concerns with the care and treatment and actions haven't been implemented or even considered because the investigation hasn't been completed, then that in itself will then lead you down the route of the prevention of future death considerations. So that's just one thing to bear in mind where you do have a delayed investigation and it's not completed for whatever reason, because then the coroner will still want to be satisfied that those concerns around prevention of future deaths do not exist. And that will be difficult when you get to inquest, if you get to inquest without the investigation, to satisfy the coroner that they don't exist, because you haven't finished your investigation. So if you've not finished your investigation, how can you then say any lapses in care that investigation has identified the actions have been fully embedded? Because it's unlikely that they won't have any immediate risks, would have, but it's the future stuff that we're talking about. Sorry, again, a really long-winded roundabout, but these questions are really good questions and they lead you on to all sorts of other considerations. So thank you very much for that question. I hope that answers it.
Our next question is, what causes the coroner to make someone an interested person?
Now, I'm going to hand you over to my colleague, Zara, to answer that question. And if she needs any additional support from me, I can follow up. Zara, are you happy to answer that question?
Hi, Sam. I can talk briefly about it. So an interested person, it's a right that's granted by the coroner to the parties involved. Now, that would mean the parties can circulate the documents to one another, ask questions of one another at the hearing, and by default, the family tends to be considered an IP as well, just because of the proximity of the relationship with the deceased. Sam can discuss further about what makes an IP an IP. Essentially, it's just whether they have sufficient interest. with the deceased. But again, Sam can go into it further. Thank you.
Absolutely. Thank you for that, Zara. So yes, basically, as Zara quite correctly said there, the coroner will consider someone an interested person where he considers that they have a sufficient interest in the inquest itself. So where we're talking about a hospital trust, it might be that the family have raised concerns in relation to the care and treatment, and it could be that those concerns potentially go to the heart of the cause of death itself, and therefore the coroner will take the decision to make that trust an interested person at that stage. If the coroner does that, doesn't always necessarily mean that there's wider issues for that particular trust, but it sometimes is easier for the coroner, especially if family have raised concerns regarding the care and treatment with that particular trust, from the outset to issue interested person status, because of course what that does is it gives that trust the right to representation at inquest, and it gives you the right to ask questions of other witnesses and interested persons at inquest as well, and almost ask questions in around the evidence. Without interested person status, you wouldn't have the opportunity to be represented or to ask questions of other interested persons. It could be, say, for instance, a scenario where you have another organisation, then say, where another organisation who is an interested person at the inquest, not necessarily family, but as Zara said, family will always be interested parties, where another organisation has raised concerns with the care and treatment at the hospital itself, and therefore it might be that you want interested person status then, because you want to be able to ask that witness about those concerns that they've raised and test that evidence yourself. So it just gives you access to representation, and it also gives you access to the full court bundle, which sometimes it can be really beneficial, because it's only sometimes when you've got the full court bundle can you see the full picture from start to finish, because whilst you've got your clinical evidence from the hospital attendants, and there may have been it may concern a patient that has come from a social care setting, then say for instance that had been transferred into the hospital setting because they've become unwell, and what you don't have until you have access to the court bundle is the a piece of the picture, if you like, in terms of what the patient journey was in the social care setting as well. And sometimes that can inform you further as a trust as to whether there are any concerns. So it could be any other organisation that's raised concerns with the care and treatment, or it could be the family themselves that have raised concerns, or the coroner may have read the evidence and thought, well, actually, I've got concerns here, I've got further questions. He might ask further questions of the trust and then decide, oh, actually, there's potential issues here, so I'm going to give this organisation interested person status, so they do have the right to be represented. But that doesn't necessarily mean at that point that there will ultimately be issues. It's a precaution in case there are issues, because what you don't want to do, and what the coroner certainly wants to avoid, is getting into inquest and then evidence coming to light where, and this does happen, and then considering that someone needs to be an interested person, because what you have then is a situation where you're at inquest, the coroner's started the inquest, and he more likely will need to adjourn if he considers then someone that hasn't been given interested person status is an interested person, because they need time to go out and get representation if they want it, or consider that position further. So it's far easier for the coroner to do it from the outset or prior to the inquest starting, if he considers someone has, and that's key, sufficient interest.
In the community, our clinicians are running into an issue whereby patients with capacity are self-neglecting and then developing sepsis or some other life-threatening condition. How would you advise an organisation to best evidence to the coroner that we are trying to work with patients to accept care or hospitalisation?
Absolutely key is your documentation, and we say it time and time again, and it must be so challenging providing the care, the attendances that you do out in the community and documenting everything, but your documentation and your notes are absolutely key. we hear time and time again, if it's not written down, it didn't happen. And coroners sometimes quote that, which makes me cringe completely when I'm sat in my chair in court, because it's not necessarily true, but you can understand why they form that view. So my one top tip for any clinician, whether it's out in the community or whether it's in a hospital setting, especially if you have someone that's refusing care and treatment for a particular condition, then it's really important to make sure you document any advice that you've been provided, or any steps that you've taken in terms of trying to get them on board with the advice and the care and treatment that you're trying to offer and provide. Can you get family involved? Do they have family? If they've got family, make sure you have those conversations with family. Again, quite often clinicians will be criticised at coroner's court because they haven't, the one where they have family involved, they're considered to be the one, person that can probably do more or assist more from that perspective. So if you can get family on board and try and help you with that, have that conversation with them, show that you've had that conversation with them, but document it, keep your notes, record it electronically. Any conversations that you have with other services, if you think they could benefit from, say, tissue viability, coming out to see them if they've got an issue with pressure sores or whatever that might be. Any conversations that you've had with tissue viability to try and get that extra support. Again, speak to them, speak to their GP as well. Say, I've got a situation here, that can you give them a call back, check on how they're doing, and see if they need any further help or assistance. So in light of that, my advice would be you document every bit of advice that you're trying to provide to that particular patient themselves, but also any documenting any conversations that took place with other services that you've tried to draw in or trying to get them to attend. We might have a situation where you've done everything that you can, get support from your team leaders as well, ask for their opinion, ask if they can help, if they've got any other ideas. So what you're looking at there is just demonstrating through your documentation that you've gone above and beyond for this patient to try and get them to accept the treatment and the advice that you're providing. And if then, you're still not getting any further forward and they've got capacity, then you can rest assured that you've done and you've taken every single step that you possibly can. And if you find yourself in coroner's court, then at that point, you're able to put all of that forward to the coroner to say, look, done everything that was in my powers to get this person to accept treatment. But sometimes people don't accept treatment. We see it quite often where, in the case of the ambulance service, we've got the ambulance service attending on patients, and they've got capacity to refuse transfer to hospital. The paramedics will do what they can, but of course they can't force them to attend if they don't want to attend. But the key thing is writing down in your documentation the rationale for taking the steps that you took, and if you left them where they were, or you didn't provide the treatment that they needed because they're refusing treatment, but they had capacity to do so, and you did everything that you can to do that, then that's as much as you can. But your documentation is absolutely key. I hope that helps.
More and more, our trust is being asked to provide evidence akin to expert evidence, particularly opinion. When challenged, we're being told by the court that the coroner is seeking to rely entirely on Schedule 5 Coroners and Justice Act. Our clinicians are becoming increasingly reluctant to comply, understandably. But how do you best deal with these types of requests, balancing the interests of the court and the clinicians?
Yeah, it's a really good question. And what we mustn't do is get confused with the civil litigation process and the inquest process. Now, clinicians ultimately are there to assist the court, whether they've had, whether clinicians have had involvement specifically themselves with that patient or not. If a coroner asks them for their view or opinion and it's within their expertise to comment, they need to oblige and they need to provide that evidence. Yes, they're not independent experts. The coroner isn't asking them to be an independent expert to the inquest, but they are experts in their field. And if they're being asked for an opinion, a respiratory opinion, for instance, whether if it's a COPD case or whatever it might be, then they need to provide their view. I'd be more concerned with why it is that clinician has any reservations as to be providing a view. If it might be that the clinician has really good, reasons for refusing because they're being asked about a specialism that's not within their expertise, then that's their response. They provide that evidence. If, say, for instance, they're being asked for, they've been provided with information and they consider they've not got the full picture of, they've not got all of the information, or it might be that they can't give a view because there's other bits of information, other considerations clinically that they don't have in front of them that the coroner hasn't provided, and therefore they're unable to arrive at a view. That's okay. That is the statement, and that's what they should put, because quite often we see circumstances whereby we have a request from a coroner to provide a view on causation. Coroners are asking more and more for clinicians to say whether something caused or contributed to the death or not. Now, when we're talking about causation and those types of statements, sometimes a clinician can provide a view on the balance of probabilities. Sometimes there's other bits of unknowns that the clinician doesn't have access to, or the trajectory of events doesn't tell us, or there's a piece of the puzzle missing somewhere where we can't give a view. If you can't give a view for whatever reason, you just have to say you can't give a view. But my advice would be, if a request from a coroner comes in for a particular clinician to provide their opinion and it's within their specialism, provide it as far as they can. If there's reasons as to why they can't provide the view, again, because there's a number of unknown factors that they need to know what would have been and what wouldn't have been to provide an ultimate outcome or whatever it might be, they just have to explain that. They don't have a crystal ball. They don't have, they can't look into the future, but they can comment as far as they can within their expertise. And if they can, they should. I hope that helps.
Thank you, Sam. And our final question is somebody saying, thank you very much for this useful reminder. As a medical examiner, I find I'm being increasingly drawn into conversations with the coroner's officer. Have you had any experience yet of this pushback?
Yeah, again, the coroner may ask his coroner's officer to have a discussion with the medical examiner about various different points of the care and treatment or medical examiner's view. Again, it's not unusual. It's been happening for years. Sometimes you will have the coroner contact and have a discussion with the medical examiner direct years and years ago, and that's just how things would have been. Just assist as much as you can. It's time consuming. I know it's time consuming. It takes you away from your clinical duties as well. But if you can help. If you can't, or you've got various bits of missing information that you don't have at your disposal, and you can't assist until you have that, say, well, I can't comment because I don't have the information in front of me, or whatever it might be. But where you can, you should assist.
Thank you very much, Sam.